This is the podcast of the Nova Centre on Business, Human Rights and the Environment. Welcome.
Welcome to the new episode of the Nova Centre on Business, Human Rights and the Environment. My name is Luís Prata Castro and I will be the research associate conducting this month's podcast interview with Professor Errol Mendes. Professor Errol Mendes is a lawyer, author, professor of law at the University of Ottawa and has been an advisor to corporations, governments, civil society groups and the United Nations. You can find more about his biography by clicking on the link. Today, our topic is related to the Nevsun Ruling Limited versus Araya case that spotlights corporate liability for human rights adverse impacts. Professor Errol Mendes, you participated as a co-counsel in a landmark Supreme Court decision in Canada in the Nevsun Ruling. Can you give our listeners a summary of the case and of the ruling? Thank you.
Absolutely. Let me give you the facts in the case because they're very interesting. 3 individuals from Eritrea, which your listeners will know is one of the most brutal regimes in Africa and in fact the whole world. It's run by a dictatorship. And they managed to escape from Eritrea and come to Canada and ask to start up an action against a Canadian company which was running a mine in Eritrea, the Bisha mine, where these 3 men said that the government had conscripted anyone and everybody which the mine needed to be forced to be laborers, in other words, to be essentially slaves for the purpose of getting maximum revenues, not just for the companies, but for the government. So over 1,000 people were conscripted by the Canadian mining company, which was operating the mine. And these 3 individuals managed to escape, came to Canada, and asked to start an action against the Canadian mining company because they alleged that they were the subjects of forced labor, slavery, cruel and degrading treatment and punishment, which amounted to what is known as crimes against humanity. Now, until this actual ruling in the case, in previous cases in Canada, they stood very little chance because these mining companies, which are many, Canada has some of the largest number of mining companies in the world, even more so than Britain or Australia, because many of our mining companies have subsidiaries which they operate around the world. And so when these sort of things happened in the past, they hired big type of lawyers, big firm lawyers, to essentially come up with all sorts of procedural challenges to these type of complaints. And the most usual ones were what's called the forum convenience, which is by way of asking the court to throw out these claims because the lawyers claim that they should go back to the country where these abuses took place and they should litigate their claims there. Now, obviously, the chances of that happening in Eritrea are almost zero. So when that was denied to the mining company, they started appealing all the way up to the top court in Canada, the Supreme Court of Canada, saying, look, in addition to us having these challenges should be upheld, we have another challenge which we are asking the Supreme Court to ignore. And that is what is called act of state. Now, just to tell your listeners what, under many common law jurisdictions, there is a principle that we should not have our courts challenge the act of a foreign state in our courts. And the mining company was hopeful that this one new issue would actually stop the complaints dead in its tracks. Much to their surprise, the Supreme Court upheld not only the previous objections to their procedural challenges, but they also said the act of state does not apply in this particular case because it has been a long time that the courts have said, look, we cannot allow a foreign country which is abusing their citizens to the extent where we can just ignore the implications of those type of wrongful acts. And so they denied the act of state challenge. Now, what was left? Well, I was co-counsel for one of the interveners in the case, which is the International Commission of Jurists in Geneva, and I also represented the chapter, the Canadian chapter of the International Commission of Jurists Canada. I am the president. And so we discussed with other lawyers what is the most effective way of addressing this issue where they've lost some of their main defenses, which is forum convenience and act of state. What else can we put forward to the court to actually give these complainants a standing to continue with their complaints? So we came up with the lawyers that under customary international law, there should be a remedy for these individuals because they were representing not only themselves, but 1,000 other individuals who were facing the same forced labor, slavery, etc. Now, many lawyers in Canada felt that there would be no chance whatsoever of this succeeding because under many common law jurisdictions, even though most common law, the United Kingdom, Canada, and some other jurisdictions, Australia, allow having customary international law be part of the common law of these countries. Usually, if you're extending international customary law to the area of civil liability of private corporations, there should be some domestic legislation which takes customary international law and turns it into a domestic law, which then gives civil liability to these individual corporations. Now, we knew that we would have a very tough position in our top court because we knew that some judges were very much traditionalists in saying, no, we should not have customary international law automatically give civil liability to companies operating in these sort of jurisdictions, which allow them to be complicit in the most serious human rights abuses. We fought very hard in the Supreme Court to speak to those judges who are not traditionalists, who asked them to think about how customary international law had developed since the Second World War. And as we all know, the international human rights movement really started flowering after the Holocaust in the Second World War, which then led to, for example, the Nuremberg tribunals, which led to the Universal Declaration of Human Rights, which led to many international human rights treaties. So we and the other lawyers who agreed with us said, look, those developments since the Second World War should be taken into account in having a newer and wider definition of customary international law, which could include applying civil liability to private corporations who have been complicit in the worst types of international human rights abuses. And we faced a lot of opposition to the traditional judges in the Supreme Court, but we were very pleased that a small majority of judges ruled in our favor. And it became the very first time of any court anywhere in the world where a top court, and a very prestigious top court, and I can explain why I think the Canadian Supreme Court is one of the top courts in the world, came to the conclusion that we agree that since the Second World War, there had been an evolution of customary international law to include application not just to states and leaders who are responsible for the gravest human rights abuses, which then imposes criminal liability on them, but we think that this should also include the worst crimes, such as those which are labeled under jus cogens, which are essentially some of the allegations made by the three men: slavery, crimes against humanity, gross abuses of human dignity, etc. The court, the slim majority of the court, said this could be the first time in the world that a court is saying this, a top court, but we are determining that, yes, customary international law can be applied for civil liability for these type of corporations, and we will ask the courts below us to fashion a remedy, because under international law, if international law says there is a right, the majority of the court said there should be a remedy. And so they said, we will turn the issue back to the trial court to come up with a way to have a remedy against these type of companies for breaches, severe breaches of customary international law. So the importance of this case lies in the fact that it is very much the first major top court in the world which has said, yes, customary international law can be used to impose civil liability on corporations.
Thank you so much, Professor. Now moving on, what can be the implications of the ruling in relation to territorial application of human rights law and the liability of parent companies for the actions of their subsidiaries operating abroad?
Allow me to expand why I think this case, taken into account with other cases in Canada, but also in the United Kingdom and the Netherlands in particular, could actually open up the door to many new claims by those who have been impacted by private companies for the worst human rights abuses, especially those which come within what is known as jus cogens, such as forced labor, such as slavery, such as crimes against humanity. Now, this case basically says, take into account customary international law, whereby plaintiffs can go to certainly the courts now in Canada, but when you apply and extend it to some of the other decisions that have been decided in the UK and in the Netherlands, you could have an entire new approach to imposing civil liability in corporations. Let me just give you, if that's okay, to give you a couple of cases from the UK and a couple from the Netherlands. In the UK, there's a case called OKBAPI, and I'll spell it OKBPABI, where the court, for the first time in the United Kingdom, actually the second time in the United Kingdom, where the top court basically said that there could be a duty of care imposed on parent companies for some of the violations that subsidiaries in a foreign jurisdiction are involved in that case, for example. And I'll give you the precise site for the case in case your colleagues or those listening want to look at it. It's called OKPABI, OKPABI versus Royal Dutch Shell Company, and it's 2021 UK Supreme Court 3, where the court basically held that the Royal Dutch Shell Company could be responsible for all the worst actions of his subsidiaries in Nigeria in terms of pollution that was taking place, which impacted on the human rights of the people there. But what's significant about that, they started using this concept that the parent company has to have a duty of care as to what its subsidiaries do. And if complainants can show there's a connection between the control that the parent company had over the subsidiary, the duty of care imposes potential liability on the holding company, the parent company. It was essentially following a previous case in 2018 in the Vendetta case, and I'll spell that case for those of you who are interested in looking that one up. It's called Lugau, Lungowe versus Vedanta, Vedanta, and the site for that case is 2018 1 World Law WLR 3575. And again, that involved a mining company where there was a leakage from the mine, which caused a lot of poisonous stuff for the local inhabitants. And yet again, the top court in the UK said there should be liability imposed on the parent company for the actions done in a subsidiary in Zambia. So when you combine the decision of the Nevsun case dealing with customary international law, you then apply these other cases, which then add this duty of care to imposing liability on the parent company. Now moving to the Netherlands, you've had some amazing decisions in the Netherlands in the civil law jurisdiction, which I think be very relevant to Portugal. You have cases such, and I'll again give you the site for this case, which is a very, very interesting case, whereby in the Dutch court, in the Hague District Court, and I'll spell this in French, Milieu Défensief, Milleu ENSIE versus the Royal Dutch Shell Company. Now, in this case, the court basically held that under civil law, the greenhouse gas emissions was causing so much undermining basic human rights that it would give authority to the court to impose a liability on the company itself. And it was following some other decisions in the Netherlands, including a very famous case involving environmental emissions, where the top court essentially said, look, if a company, its emissions are so grave that it's imposing possible pollution impacts on the local population, it could be a violation of the constitutional rights of Dutch citizens for the right to life and privacy. So I can give you the sites for that case too, but it's very fascinating that in a civil law country as Portugal is, that there's now applications of constitutional protections to link that to some of the bad operations of major companies. And finally, in the Netherlands, it is very interesting that, again, against the Royal Dutch Shell Company, the Dutch Court of Appeal essentially ruled again that there was a duty of care for the Dutch company in Nigeria to avoid pollution which would impact on human rights in the Netherlands. So what you have is a combination of the Nevsun ruling, which expands the whole area of corporate complicity and therefore arising civil liability, with the UK decisions and now the Netherlands position, which is a civil law country. So now we have a commonality between common law and civil law, which provides a lot of opportunities now for the potential imposition of civil liability on corporations who are involved in the most serious human rights abuses in the world. So that's where I think we should be combining not only the Nervsun case, but also some of the prior decisions in the Netherlands and the UK for lawyers to basically start thinking about finding new ways of dealing with civil liability imposition of companies which are not obeying the most serious obligations they have on human rights and the environment too, not only human rights, but now under the Dutch decisions, even under environmental damage that is caused by these companies.
Thank you, Professor, for your fruitful contribution. Does the Canadian case law present a more fertile ground for tort claims based on corporate human rights violation than the US Alien Tort Statute? Thank you so much.
That's the most interesting development since 2015 to the present day. Everyone thought that the country which would provide the most protection to those who are seeking action, civil liability against corporations who are engaged in the worst human rights abuses would have been America. Sadly, however, when a decision of the US Supreme Court happened in 2017, which essentially, 2013, sorry, April 17th, 2013, all the hopes that people had for the United States was dashed. Because since that decision, everyone was hoping that a particular act in the United States called the Alien Tort Claims Act, which is a very old act, it's a 1789 act, which was originally passed in the United States, primarily to have liability imposed on pirates. But under this act, there was a potential for claimants to come to the US, the federal courts, and basically under this act say that there have been wrongful acts, torts, as it's called in the United States, committed under the law of nations and under treaties that the United States have signed. And until the early 2013s, there were about 50 cases where people brought actions under this. None of them were really successful. Two eventually ended up in judgments, but one of them was a default judgment. But there was still hope that ultimately the Supreme Court would change its mind and allow this act to be the main act by which people can come to the United States and claim that private corporations were committing the worst human rights abuses and then sue them under this act. Much to the surprise of many people, the Supreme Court of the United States issued a decision in a decision called Kiobel, Kiobel, versus the Royal Dutch Company. The Supreme Court of the United States said, we are changing our direction on this act and saying that you should assume there's a presumption against the extraterritorial application of the Alien Tort Claims Act. And so for that reason, from now on, just having an American company, a holding company, one of his subsidiaries being involved in human rights abuses in a foreign country, this act does not apply, and therefore, please do not come again to this court or any court in the United States claiming that you could have civil liability under this act. It devastated many people who hoped that the United States would be the main area by which people could come, because as you know, some of the largest corporations who have been involved in human rights abuses are based in the United States, and many of them still to this day are involved in many allegations of human rights abuse around the world. So after this case and subsequent cases where the Supreme Court reaffirmed that there would be a presumption against extraterritoriality, so therefore the act does not apply, people were hoping that other countries would come to the rescue of using the law to prevent these companies getting away with abuses of human rights. And that is where people started turning their attention to the United Kingdom, to Canada, and the Netherlands. And that is why I was very keen to inform you and your listeners that now the hopes for further accountability has really moved from the United States to the United Kingdom, to Canada, and the Netherlands. Now, hopefully, there will be lawyers who will now start looking at how to connect the ruling in Nevsun with ruling in the United Kingdom and the rulings in the Netherlands, especially for those civil law countries like Portugal, who may be able to use some of the principles from Canada and the United Kingdom, but then extend it to a civil law jurisdiction where you have constitutions which protect fundamental human rights, such as the right to life, the right to privacy, and connect these three areas to come up with much interesting and very potentially far-reaching ways to attach civil liability on corporations, not only in the common law world, but now attaching some of the decisions on the civil law world to actually extend the reach for lawyers to impose civil liability for corporations.
Thank you so much, Professor. Now moving on. What barriers to effective access to remedy do claimants still face when bringing this type of claims in Canada? Thank you.
Yeah, I'm really glad you asked that question, because as lawyers, we have to acknowledge there are major problems within our own profession. And the biggest barrier, and I've been, as you can tell, I've been involved in some of these cases. The biggest barrier that complainants have is essentially finding lawyers who are able to bring these cases and actually use their own resources to bring it all the way up to the Supreme Court of the country, because these are very expensive, extremely expensive lawsuits, which the mining companies and the extractive industry companies, they have enough resources to hire the biggest law firms, the richest law firms, and basically not worry about the funding needed to bring these cases. I think it's a really bad aspect of our own profession that these cases will have to rely on lawyers, and I'm hoping that the young lawyers, for example, those who are listening, can find ways to band together as groups, maybe seek funding from other sources to allow them to stop these actions. Now, that's only one of the challenges. Another challenge is in many countries, including now less so in Canada, there are still these procedural challenges that the big law firms throw against these lawyers bringing these cases. For example, still in Canada, they often bring up this forum convenience argument. But now we have cases in Canada which allow lawyers to say, you could do that in the past, you can't do that anymore. And cite the Nevsun case, cite two other cases where the court said, no, we will not allow this procedural challenge to succeed because we will always look to see whether or not in the country in which these abuses happen, is there any chance whatsoever of these type of actions succeeding. So, for example, there's no chance that these actions could have succeeded in Eritrea in the Nevsun case. In another case called Garcia versus Tahoe Resources, TAH Resources, our top court basically refused to accept this forum convenience challenge because even in a country like Guatemala, the court came to the conclusion that yes, it's not as bad as Eritrea, but the chances of the plaintiffs actually getting independent justice in Guatemala is not high, and so they refused to accept the forum convenience challenge. So I'm sure there are many such procedural challenges, both in similar countries, but also in common law countries. But increasingly, we can now cite decisions where lawyers can say, you tried that before and you did not succeed, and you should not succeed now.
Professor Errol Mendes, thank you so much for your amazing contribution. And thank you all, for all our listeners to the Nova Center on Business and Human Rights podcast.